Welcome to the deep dive. Today, you've brought us some fascinating sources, really digging into how ancient legal thinking developed.
That's right.
We thought we were starting with the Roman Lex Aquilia, their big law and damages.
Mm-hmm.
But the material actually tells a much bigger story, doesn't it? It's about how societies, both Greek and Roman, moved away from pure revenge towards, well, actual systems of liability.
Exactly. It's a huge shift we're tracing, not just dry old laws, but, how did Athens and Rome tackle that basic problem? Someone harms someone else. What happens next?
Right.
They went from these really personal systems all about honor, feuds, status, to something, especially in Rome, surprisingly systematic, focused on calculating loss, on compensation in, well, money terms mostly.
So that's our mission for this deep dive. Looking into that complexity, we'll explore let's say, the very intense personal world of Athenian conflict resolution.
Yeah, very personal.
And then we'll shift gears to Rome, to the almost modern-feeling way Roman jurists worked out specific rules for property damage, for injury, rules that really are the ancestors of our tort law today.
And that's the so what, isn't it? That core question, who pays? How do we stop the cycle of revenge? That's what drove them to invent ideas we just, well, take for granted now.
Like negligence, fault.
Exactly. Negligence, fault, figuring out cause and effect, how to calculate loss without bias. It's this move from judging the person, their character, their status, towards judging the action itself, the objective outcome, what actually happened, what damage was done.
Okay, let's start that journey in Athens, 5th, 4th centuries BC. The legal system there, especially for really serious stuff like homicide, seems deeply tied to family, to personal honor.
Very much so. The traditional way to prosecute a killing, the dikaiphonu, had this strict rule. Only the victim's kin could bring the case.
Why was that so important? Just keeping it in the family?
Well, yeah, it served a purpose. It kept homicide prosecution fundamentally private. The idea was the family's security was violated, so the duty to seek justice, or maybe vengeance initially, rested with them. It reinforced this notion of a blood debt, something only the immediate family could pursue. The state, provided the court, the structure, but the drive, the initiative that came from the family.
But Athens was a bustling democracy, right?
Yeah.
Lots of public life. They couldn't just have suspected murderers wandering around the agora while everyone waited for a cousin to file charges.
No, exactly. And that's where this alternative procedure comes in, apagoge. It's quite something.
Apagoge? What does that mean, literally?
It means leading away.
Yeah.
It basically let a citizen skip the whole kin requirement under very specific circumstances.
Okay, like what?
If a suspected killer was caught circulating in the temples and around the agora, so right out in the open in the most sacred and public parts of the city.
Wow. So just hanging out where they shouldn't be.
Pretty much. Contaminating these vital public spaces, if you saw that, you as a citizen could arrest them yourself. Right there. And take them straight to prison to await trial.
Hold on, that sounds incredibly risky for the person doing the arresting. You're acting like a policeman, but without a badge, essentially.
Oh, absolutely risque. Because the idea was that these public spaces, the religious and political heart of Athens, were polluted by an unpunished killer's presence. So apagogia was like an emergency measure.
But there had to be a catch, right? To stop people just accusing rivals left and right.
A massive catch. The state put in a huge disincentive. If you, the accuser using apagogia, failed to get at least 1/5 of the jury votes at the trial,
Yeah.
you faced a fine of 1,000 drachmas.
1,000. How much was that back then?
Enormous. Several years' wages for an ordinary worker. A potentially ruinous amount.
So why make it so punitive? Was it just about stopping malicious accusations?
Not only that, it was also about protecting the traditional kin-based system. The state was basically saying, look, the family has the primary right here. If you're going to shortcut that, you better be absolutely sure, and you need serious public backing.
Okay.
Otherwise, you pay. It showed that the established order was still paramount. Only a really blatant offense against public order and safety justified using apagogia.
This whole environment life, fortune, reputation, constantly on the line.
Yeah.
It leads us straight to this idea you mentioned earlier, ekthra. Litigation as just another form of personal feud.
Absolutely. In Athens, the courtroom was often just, well, another arena for ongoing social or political battles. Ekthra wasn't just, I don't like you. It was deep-seated, sometimes inherited rivalry.
We see that in the speeches, right?
Vividly, you look at orations like Lysias 13. The speaker is prosecuting Agoratas, and he flat out tells the jury, this is ekthra. This guy informed on Democrats, including my relatives, and that's why we're enemies, and that's why I'm bringing this case.
So the lawsuit wasn't just about proving one specific illegal act.
Often not just that. It was like the next move in a long game. The litigant had to persuade the jury that siding with him was better for the city, that his opponent was a bad element, an enemy.
So justice gets mixed up with politics and social standing.
Completely. Litigants wouldn't just argue the legal points. They'd constantly appeal to the jury's sense of advantage, framing it as, who's the better citizen here? Who contributes more? Who's less of a threat to our democracy? Justice was tied up with civic virtue, with political alignment. If you could paint your rival as a worse citizen, maybe disloyal, maybe impious, that helped your case enormously. You deserve to win.
And this constant focus on status, on protecting your position, brings us to hubris, which is often translated as outrage. But it seems like more than that.
Oh, much more. Hubris wasn't just any crime. It wasn't simple assault or theft. It was a specific kind of attack aimed right at the honor, the status of a free citizen. A deliberate attempt to humiliate them, to push them down the social ladder.
It was considered really shameful, wasn't it?
So shameful that victims sometimes wouldn't even report it if it happened to, say, their wives or sons, because just talking about it could magnify the shame, the dishonor.
What made something hubris rather than just, say, assault? Was it the level of violence?
Not necessarily the physical harm itself, but the intention behind it, the intent to degrade. The symbolism was key.
Like the whip example.
Exactly. The sources are very clear. Hitting a free man with a whip, that was automatically hubris. Why? Because whips were used on slaves. So using it on a free man was a deliberate statement, I'm treating you like a slave. It attacked his fundamental identity as a citizen. The law was fiercely guarding that line between free and enslaved.
And this obsession with status and honor carried over into, well, very sensitive areas like sexual matters.
Absolutely. Things like adultery or sexual violence were often framed as hubris, not just because of the act itself, but because it was seen as a direct attack on the husband's or father's honor, his control over his household.
The shame was public.
Public and severe. It damaged his reputation. And because the crime was understood in terms of honor, the Athenian system actually allowed for, even expected, a response designed to restore that honor by humiliating the perpetrator in a comparable way.
Which leads to some pretty brutal forms of revenge we read about.
Yes. The accepted payback for an adulterer's hubris could include public sexual humiliation. The most notorious example is raffinizing,
Which involved a radish.
The term suggests forced penetration with a radish, or maybe something similar, possibly along with castration. It sounds barbaric to us, and it was.
Yeah.
But it highlights that the goal wasn't abstract justice or even financial compensation in these cases. It was about restoring the victim's damaged honor by publicly, physically, and symbolically degrading the offender. The whole system was geared towards managing status and allowing for retribution, albeit within certain, often violent limits.
Okay, let's shift now. From Athens, where everything seems tied to personal honor and feud, to Rome. The difference feels stark. Rome seems much more focused on systems, on quantifying things, especially property. How did Roman law manage that shift? How did it get flexible enough to run an empire when it started with rigid old laws?
Well, a really useful way to think about this is through the framework laid out by the legal historian Henry Sumner Maine. He talked about three main ways, three instrumentalities that law uses to keep up with society as it changes.
Okay, what are they?
He identified legal fictions, equity, and legislation, usually appearing in that historical order.
Right. Can you break those down quickly? Legal fictions. That sounds like pretending something is true when it isn't.
Kind of, yeah. It was the earliest method. The law pretends not to change, but the outcome does. Like treating a foreigner as if they were a Roman citizen just for this one lawsuit, so the old rules could still apply. It maintains the form, but changes the substance subtly.
And legislation. That's just passing new laws, right? Like the Lex Aquilia itself.
Exactly. Direct, explicit changes. But Maine argued that legislation is often the slowest way to adapt.
So that leaves equity.
Equity, and especially what Maine called remedial equity fairness, discretion, finding solutions outside the strict letter of the old law. He argued that equity, in practice, is often older and more influential than formal legislative changes. It's the engine of adaptation.
And in Rome, the main driver of this equity was the praetor.
The praetor, absolutely.
Yeah.
This magistrate was in charge of the courts, and his office became the key source of flexibility. He had the job of making the old civil law, the Neopathic civil, work in a changing world, often without actually overturning ancient statutes.
How did he do that? Through his edict.
Precisely. When a praetor took office each year, he issued an inaugural proclamation, his edict. In it, he'd announce his policies for the year, basically, what kinds of lawsuits he would allow, what defenses he'd recognize, what remedies he'd grant.
So an annual policy statement, how did that lead to long-term legal development?
Because if a particular rule or procedure introduced by one praetor worked well, if it was efficient, fair, solved a real problem, the next praetor would likely just adopt it into his edict.
Ah, yeah.
So over time, you get this accumulation of successful innovations. This growing body of established, accepted reforms became known as the perpetual or continuous edict. It didn't replace the old civil law, but it ran alongside it, smoothing its rough edges, filling its gaps, prioritizing practical results over ancient formalities.
It sounds like they basically built a system of judicial discretion right into the office, allowing the praetor to keep the old forms only if they still made sense and discard the rest.
That's a great way to put it. And a perfect example is how the praetor reformed the will. The really old Roman will, based on a symbolic sale called mancipation, was incredibly ritualistic.
Right, I remember reading about that. Lots of witnesses, scales, a symbolic buyer.
Yeah, 5 witnesses, the liberpens holding bronze scales, the familia emptor acting as the buyer of the estate. Pure ceremony, really, from a time before widespread literacy.
So the praetor looked at all this ancient ritual and asked, what's actually doing the work here? What prevents fraud in our society? He realized that in a more complex, literate world, the real security came from a clear written document and credible witnesses.
So he kept the witnesses.
He kept the witnesses. In fact, he increased the number to 7, probably for extra security, requiring their seals on the document. But he completely ditched the liberpens and the familia emptor. They were just symbolic baggage by that point.
Makes sense.
He kept the part that provided a real safeguard, the witnessing, but got rid of the pure ceremony. It's classic Roman legal thinking, focused on substance, on practical security, over rigid, outdated forms.
Now let's apply this systematic Roman thinking to something really difficult. Slavery. Roman law is famous, or infamous, for defining slaves as property, as res things. How did this evolving legal system handle the awkward fact that this property was also human? That's a huge tension, and you see the Roman jurists wrestling with it. Legally, yes, the slave was property, an object of ownership. But philosophically, especially with the influence of Stoicism and the idea of a eius natural, a law of nature.
Right, the idea that nature made everyone equal.
Exactly. The theory was that, fundamentally, all humans are equal. Slavery, they reasoned, wasn't natural. It was an institution created by human convention, by the eius gentium, the law of nations, basically the customs of war and society, not by nature itself.
So this philosophical idea acted as a kind of counterweight. It moderated the harshness of the slave as property rule.
It did provide a certain moderation. It meant that even though the slave lacked civil rights, the law couldn't completely ignore their underlying humanity. The sources point out something interesting here.
What's that?
That in legal systems later on, which were heavily influenced by Roman jurisprudence, they mentioned the Code of Louisiana, specifically the actual condition of slaves, while still terrible, was generally less wretched than in systems built on different theories of human degradation, theories that lacked that Roman natural foundation.
So even if they were property, that flicker of natural human status offered some minimal theoretical protection or consideration.
It seems so. It created this constant tension. The law had to calculate the loss in property terms if a slave was injured or killed under laws like the Lex Aquilia. But the jurists were always aware they were dealing with harm to something that was fundamentally human. And this wrestling forced them to develop a much more nuanced legal vocabulary, going way beyond just simple ownership or dominion.
Okay, this brings us right into the heart of Roman practicality, especially when it came to money and fixing wrongs. You mentioned an action called condictio. You said it shows this Roman focus on just getting the money back, undoing unjust enrichment.
Yes, condictio is really interesting because its main goal was just to fix a financial imbalance. If someone ended up with money or assets that they had no right to, usually through some dishonest means or mistake, condictio was the tool to get it back.
And the key thing you're saying is that it wasn't about punishing the wrongdoer necessarily. It was about the money itself.
Absolutely. It chased the money. The prime example of this focus on just restoring the economic situation is that you could bring a condictio against an heir.
Against the heir, even if the heir did nothing wrong.
Exactly. Imagine someone took a huge bribe to cheat someone or influence a judge, then they die before the victim can sue them. The criminal charges, if any, might die with the perpetrator.
Hey.
But The bribe money is now part of the estate inherited by the heir. Under Roman law, the victim could potentially use condictio against the innocent heir to recover that specific ill-gotten sum.
Wow. So the law is saying, we don't care who has it now. That money doesn't rightfully belong in this estate. It needs to go back.
Precisely. It shows a system laser-focused on reversing the unjust gain, stripping it away regardless of who holded it. It's pure economic restoration, moving beyond punishment of the individual act.
All right, let's turn to property loss more directly, the kind of thing that Lex Aquilia dealt with. Calculating damages. The Romans changed things significantly with this idea of interest, didn't they? Especially for theft. It wasn't just about the owner anymore.
No, and this is a huge step away from more rigid systems. The Roman action for theft, the actio furti, didn't strictly require the plaintiff to be the absolute owner, the holder of dominium.
So who could sue?
Anyone who could prove they had an interest in the property's safety. Basically, anyone who stood to lose financially if the thing was stolen.
Like who? Give me some examples.
Okay, well, someone who had lent the item out, like a bailee. Or someone who had rented it out, someone holding it as a pledge or pawn. Even someone who just had the right to use it, like a usufructuary.
So lots of people, potentially.
Yes. The goal was to compensate the person who actually suffered the economic loss, not just the person with the fancy legal title of owner. It made the system much more practical.
But there was that moral catch you mentioned, the idea of honest interest.
Right. This shows that Roman law wasn't purely about economics. There was still this ethical dimension. The interest you were suing based upon must be an honest interest.
And the classic example is the thief suing another thief.
Exactly. Thief A steals something. Thief B then steals it from thief A. Now, technically, thief A has an interest because the original owner might eventually sue him for the item. So thief A has suffered a loss by thief B stealing it.
But the law wouldn't let thief A sue thief B.
No, because thief A's interest was based on his own dishonest act, the first theft. The jurists drew a line. They wouldn't let the legal system be used to protect gains derived from crime, even if that meant thief B got away with it, at least in terms of a suit from thief A. It's a fascinating moral constraint on a very practical system.
Okay, practicality also forced them to deal with tricky causation issues. The original Lex Aquilia seems quite narrow, direct action, right? Killing, burning, breaking, physically doing it.
Yes, the original language likely focused on damage caused corpore by the body to the body. Direct physical impact.
So pushing someone's slave off a bridge that's covered.
That's covered. Direct force. But what if you cause the damage indirectly? You provide the means, the cause, but don't actually strike the blow yourself.
Like the example in the sources about killing bees with smoke.
Perfect example. You don't physically touch the bees. You create smoke. The smoke kills the bees. The Lex Aquilia, in its strictest sense, might not apply.
So how did they handle that?
Through the praetor's flexible toolkit again. They developed what was called an actio in factum, an action on the facts.
Ah, a workaround.
Basically, yes, it was action granted by the praetor specifically for situations where wrongful conduct caused loss, but didn't fit the precise wording of the old statute. So the person who smoked out the bees would be liable under an actio in factum.
So it closed the loophole for indirect causation.
It did. It made sure victims could get compensation even if the harm wasn't caused by direct physical force. It expanded the law's reach to cover negligence, indirect acts, a much wider range of harmful behavior. Very important development.
We have to dig into some more specific rulings from the digest, these interpretations that really flesh out the Lex Aquilia principles, starting with intent versus outcome. This seems crucial.
It really is. The Roman jurists, especially when dealing with property damage under the Lex Aquilia, leaned heavily towards an objective standard. What mattered most was the harm done to the owner's property.
And the example given is stark. Killing a slave you mistakenly thought was a free man.
Exactly. Your subjective belief, your mistake, even if made in good faith, didn't erase your liability to the owner for the loss of his property. The focus was on the result. The owner suffered a quantifiable loss because of your action.
That feels very different from the Athenian focus on hubris, where the intent to dishonor was the whole point.
Completely different emphasis in civil liability, yes. For Aquilian liability, your intention might affect other penalties, maybe criminal ones, but for compensating the owner, the primary question was, did your action cause the loss? If yes, you pay. The law is trying to restore the economic value, not primarily judge your moral state in that context.
And their approach to situations where multiple people might be involved, concurrent causes, That also seems surprisingly strict.
Very strict. They demanded clear proof linking a specific defendant to the specific harm. The example used is quite dramatic. Two slaves are fooling around, jumping over burning straw. One gets knocked in and dies.
Yeah.
If you can't prove which slave knocked the other one in, if it's not known which was knocked over by which, then neither can be held liable under the Lex Aquilia.
Wow. So even though someone clearly caused the death, if you can't pinpoint who, both walk free, civilly at least.
Correct. The system refused to assign liability based on probability or group responsibility in that context. It demanded specific causation, no lazy judgments allowed. You had to draw a clear line from defendant A's action to the resulting damage. If you couldn't, the default was no liability. Very systematic.
They also tackled the age-old problem of self-defense versus using too much force, a balancing act every legal system struggles with.
The basic principle was clear. Using force for necessary self-defense was allowed, permitted by all laws, as they put it.
Oh, with limits.
Strict limits. The example is, you're attacked, you throw a stone at your attacker in self-defense, but you miss, and the stone hits an innocent passerby.
Are you liable for hitting the passerby?
Yes, you are liable under the Lex Aquilia for the injury to the passerby.
Even though you were defending yourself?
Yes, because the permission to use force extends only to the attacker, and only so far as is necessary for self-defense and not for revenge. Hitting the bystander is outside that scope. It's either negligence, you threw carelessly, or excessive force. You weren't controlling your actions properly. Once your defensive action causes harm beyond that justified zone, you're responsible for that collateral damage. It's about proportionality.
And finally, they had these really intricate rules for calculating damages when someone was wounded first and then died later from the wound. Seems like a potential minefield for double charging.
It does seem like it could lead to that. The owner could, technically, bring an action for the wounding first. Then, if the slave died later from that same wound, they could bring a second action for the killing.
So the defendant pays twice.
But here comes the Roman genius for calculation and fairness. They built in a safeguard, the defense known as the plea of fraud, exceptio doli.
How did that work?
It prevented the plaintiff from recovering more money across the two lawsuits, wounding than killing, than they would have received if they had just brought the single action for killing in the first place.
And the action for killing covered?
Under the Lex Aquilia, the action for killing covered the slave's highest market value in the year leading up to the death. So the exceptio doli capped the total recovery from both suits at that maximum value.
Clever. It stops the plaintiff gaming the system for extra profit.
Exactly. It ensured the compensation was fair, restorative, tied to the actual financial loss, not punitive or exploitative. Again, the Roman focus is relentlessly on accurate monetary restoration.
So wrapping this up, we've journeyed quite a distance. From Athens, where law was so deeply tangled up with personal honor, political rivalries, this concept of ectra, to Rome, where, you have the praetor's innovations, the incredibly detailed work of the jurist, and they build this system. Specific, calculable rules for damage, for who has an interest, for causation, for liability, really the foundations of modern tort law.
That shift from judging status degradation to quantifying financial loss, that's the critical takeaway. The Roman jurists, especially through how they interpreted and applied the Lex Aquilia, give us the basic vocabulary: fault, negligence, market value compensation.
Yeah.
Concepts that are just fundamental to tort law everywhere today. They really did systematically change the main goal of civil lawsuits, moving it away from personal revenge or political point scoring towards just making the victim whole, economically speaking.
And that Roman rule we discussed about liability, even when you make a mistake killing a slave you thought was free, you're still liable.
Yeah, that rule really makes you think, doesn't it? It forces us to consider what the law is primarily trying to achieve when it deals with compensation.
Right. Is it about the objective harm, the actual loss the victim suffered, making sure that gets fixed? Or is it more about the wrongdoer's state of mind, their intention?
The Romans, at least in civil liability for damages under the Aquilia, came down pretty firmly on the side of the objective outcome. Restore the economic balance first.
Which leaves us, and you listening, with that question. What's the ultimate aim? What's the most just way to restore things after harm is done? Is it about punishing the intent or repairing the damage? The Romans, for civil law, largely chose repair, and that choice still shapes our legal world profoundly.